Welcome back to the House Judiciary Committee this Tuesday afternoon, May 5th, and we're going to turn back to S-193. That's draft number 4.1. And just to give folks a heads up as far as the likely path for this is, so we're gonna go through this, and if we don't get through everybody this afternoon on this draft, we have tomorrow morning. We can do people tomorrow morning. And tomorrow morning, this draft will actually be updated with corrections input, and that will be going, will be a joint hearing on human services and corrections to take a look at a draft that includes what we have and what corrections is suggesting. We will retain jurisdiction and probably receive any of the input from corrections and human services, and the goal is to pass this out by the end of the week. That's so we'll probably be back at this on Thursday at some point to look at whatever we're getting from corrections and human services. Yeah, exactly.
Just a question, Chair. So my understanding is that corrections and human services are having a joint hearing tomorrow.
Yes.
Do they offer us to be part of that?
Yeah.
Seeing as we have jurisdiction?
Right. The concept was that we were going to actually send this over to corrections. We're going to be relieved of it. But in further conversations, that got a little complicated, so we're going to keep it. They're going to be really looking at the sections that's in their jurisdiction.
Okay.
So that's why, I mean, we don't have anything scheduled 11, so folks are welcome.
I do feel inclined that I might want to join.
Yeah.
Just so I have a full picture of what the other committees are considering with this.
I was thinking of going it, but I have other obligation, but other folks, I am assuming it's in either room 11 or room 10, and I'm sure
room 11.
Yeah.
Thank you, Nate.
Yeah, so I think it'd be good to track.
Yeah, I was just curious if they gave us an opportunity to join.
Yeah, there was no reason for us,
Yeah.
because it's not the parts that
That's fair.
But they are going to be going over what we've worked.
Yeah.
So with all that, I'll turn it over to Eric to actually let me do one other introduction.
Yeah, please.
And that is what this incorporates is from the latest testimony, but also Eric and I had the opportunity to sit down with the commissioner of Dale and the general counsel for Dale and a couple other folks who were there as well. And we really looked at some issues related to Developmental Disabilities Act 248 and Dale's jurisdiction. And this also, the bulk of what the changes are in here are from that input that we received from Dale. So with that, now over to you, Eric.
Thank you, and good afternoon again, everybody. Eric Patrick with the Office of Legislative Counsel. Switching gears, as the chair was explaining, to S-193 now, looking at proposed version 4.1 of the committee strike call amendment. As the chair was saying, much of what we'll look at here, not all of it, but much of it will revolve around the way that the Department of Developmental Aging and Independent Living, Disabilities Aging and Independent Living, interacts with the proposed forensic facility. We've been thinking about that a little bit last time. There've been some intervening discussion. So there's been a proposal that you look at that takes a different approach, a different route, which I'll get to in a moment. But I'll start with just reviewing the highlighted changes that we can see between this draft and the previous one. You'll see on the very first page, this gets at the concept that the committee has been discussing of, how it is that a person actually ends up in the forensic facility in the first place. We already know what the criteria are. Those are unchanged on page 1. We'll get to another one on page 2, but it was sort of a process-oriented question. And the language in the previous version said that the person would be remanded to the Secretary of Human Services. Well, that person could be at the moment when they are found incompetent to stand trial. And if they meet these other criteria, they could conceivably be in the custody of the Department of Corrections because they might be being held without bail, as Subdivision 2 says. They might conceivably be in the custody of the Department of Mental Health on an order of non-hospitalization, for example. That could also be the situation in which a person would be prior to the finding of not being competent to stand trial. So rather than try and specify all that at the outset, it made sense to just speak generally and say a person shall be placed at the forensic facility, and then whatever custody they are in prior to placement would be whatever custody they are in. If they meet the criteria, then they would be placed there, and you'll see The first three criteria are unchanged. It's a life sentence offense that they have to be charged with. They're either being held without bail or they are suffering from a qualifying condition that would create a substantial risk of bodily injury to another person. They're not currently receiving treatment. I'm over on to page 2 now. Under an order of hospitalization. And you'll see the language struck here on page 2 with subdivision B. And that's in the last draft. This is the Dale issue I was just mentioning. And the idea here was the way it had been written previously was that in the same way that people who are currently subject to a hospitalization order at the Department of Mental Health would not go to the forensic facility. And under the previous draft, similarly, people who were subject to an order of commitment to Dale would also not be sent to the forensic facility. It helps for a moment here to look at some language that's in existing statutes. That's cross-referenced there, section 4823. So I'm going to go ahead and hand this out. It's also online, but just in case, I've sent it to Nate. It is on the website if you want to look at it. But this sort of is the basis for many of the other changes that we're looking at in the rest of the bill. So it's helpful to at least look at this language once. So if you look at the page I handed out, it's actually turn it over. It's on the back, second page, the back side of it. And you'll see subdivision 4 there defines person in need of custody, care, and rehabilitation. Now, the reason that I want to point that out to you is that under existing law, we've talked about this before in this committee. If a person is found incompetent to stand trial, if it's as a result of a mental illness that they are dangerous to another person, then they're committed to the custody of the Department of Mental Health. But if it's as the result of a finding that a person is in need of custody, care, and rehabilitation, which you see the definition that I just handed out, then the person is committed to the custody of Dale. That's existing law, and that's after a finding of not being competent to stand trial, or NGRA as well. But for the moment, we're focusing on the competency population. So that's the background. The idea had been, all right, well, and again, if you look at that definition a little more closely, person in need of custody, care, and rehabilitation means a person who, with an intellectual disability, which means significantly sub-average intellectual functioning, existing concurrently with deficits in adaptive behavior that were manifest before 18 years of age, who has inflicted or attempted to inflict serious bodily injury to another. So there's sort of a dangerousness component to it, phrased differently, but that's an idea. Or who has committed an act that would constitute, and then it lists several offenses there. And lastly, subdivision C, this is appropriate for the rest of the bill we're going to look at as well, for whom appropriate custody, care, and rehabilitation can be provided by the commissioner in a designated program. So that's the existing definition. That's if, again, in the current law, someone is found incompetent to stand trial. If the court finds that they're a person in need of custody, care, and rehabilitation, well, that person goes to Dale, not to DMH. See what I mean? The DMH route is if the person is dangerous to self or others as a result of a mental illness. So different possible tracks that exist. So in the previous draft of the bill, well, first, you'll see the way the bill is under lines 1 and 2, which were unchanged. So if a person does go that route, if they're hospitalized as a result of a mental illness that causes them to be a danger to themselves or others, they don't go to the forensic facility, right? See, that's the way this is written. And the previous draft you looked at said also, similarly, if they're subject to an order of commitment to Dale, and that's based on this definition that I just handed out, then they also wouldn't go to the forensic facility. So this bill, this amendment, I should say, takes a different approach. It doesn't carve them out at the beginning, the way you see the previous draft did, said these people don't go to the forensic facility at all. Instead, the approach is going to be, and we'll see this a couple of pages down the road, is that rather than excluding that population completely, they go through the non-restorability process that you have in the bill for everybody else. And if it's found that they're non-restorable, not restorable to competency, then they would go to Dale, non-restorable and not dangerous, I should say. Actually, let me back that up. It's non-restorable, period. They're not restorable, then they go to Dale. And so you see it's a different stage of the proceedings, you might say, where they would be committed to Dale custody. So that it wouldn't be right away like this. They wouldn't be excluded from the outset. But if it's found subsequently in the proceedings that the person is not restorable, again, you'll have many witnesses other than myself who could testify to the clinical aspects of this. But since that definition is resting upon this idea of significantly sub-average intellectual functioning, seems to make sense that in many of those cases, that person is not going to be restorable, right? That's so that they are found to be non-restorable in this proceeding that you have set up, then they would go to Dale. We'll see when we get to the details of this. There's an exception to that if, and it sort of turns on, and look at that definition, the language in subdivision C again that I handed out, for whom appropriate custody, care, and rehabilitation can be provided in a designated program. There's an opportunity, a mechanism in the language for the commissioner to say, well, we don't have that quite yet. So they'll stay at the forensic facility until we get it. That's the sort of overarching way to put it, but that's the general process that you'll see when we get to the language. So that's the idea. It's struck here, but the idea, the concept of that population being committed to the custody of Dale still exists a little bit later in the proceedings, and we'll see when we get there.
Eric, like any good book, I jump to the end to figure out what the end, how the story ends.
Right.
I'm wondering, so I see some mention of corrections in the latter part of the bill, and I know that you're going to get there, but I'm wondering, at least in the initial outset of the language, how this has been modified. How does it interface with corrections currently?
You mean
Like this process that you've just outlined
Right.
on pages 1 and 2. I'm curious, like where's corrections in all this in the equation?
yeah, I think that if you sort of look as we go through it, you'll see that sort of the clinical services that are being provided are generally by, and if you look at the term on the second page, because it's a term that has been proposed by DMH, line 13, by the Agency of Human Services Medical Director. So that's sort of the clinical side of the treatment of the person while they're at the facility, whereas more the management of the facility, the operation of it, that sort of thing is sort of still in the bigger picture within the Agency of Human Services, which includes corrections. It's kind of the conversation we had last time. That they could delegate that piece of it to DOC.
Well, I think, and again, this probably isn't for you. It's probably for one of the witnesses that we have upcoming, but I believe this was the position that is currently, they have headcount for, but it's not currently filled.
That one, the medical director?
Yeah.
That's a good question. I'm not sure the answer to that, but
I think that's the case.
Right.
Is that the case? Yeah. You're recruiting currently. Okay. Thank you.
Yep.
Yeah.
Is it best to, is it better to hold, Eric, if I have a question a little bit more about this process, do you want me to wait, and is it better to just wait until we get to that?
either way, whatever you think,
Or if
you know.
Point me to it.
Yep.
Because I'm just wondering, I'm trying to remember, in the meantime, so for folks who might end up being, committed to the custody of the Dale Commissioner,
Right.
before that determination is made, because we're not setting that as an off-ramp, like right at the outset, they would conceivably potentially be held wherever this forensic facility is, right? They'd be in the forensic facility, at least temporarily.
Yeah, I think so. Possible. It's also possible, just if you look at, I get right where we were on page 2, lines 12 to 15. So backing up for a second. So once the person is placed in the facility, their placement there has to be reviewed every 6 months. And I'll talk a little bit about how that 6 month is calculated in a second, but every 6 months or upon the determination, this is lines 12 to 15, if the Agency of Human Services Medical Director determines that the person is likely competent to stand trial or that it's unlikely that the person's competency can be restored. So in theory, because that can happen at any time, that could happen the day after the person gets there. In theory, if it's apparent to anybody, I should say, the soon to be filled position of medical director determines that, hey, this is a person whose competency is not likely to be restored, they could let the commissioner know right away, and there could be a hearing on that, at any time after the person was placed there and before that initial 6 month review period. But yes, until whenever that happens, they would be right. But so that's possible. Again, depends on the particulars of a individual case. But until whenever that happens, yes, that's what they would do.
Okay, so the shorter of either, right, so the medical director could flag a person, say, okay, wait, let's look at this right now.
Yeah.
Or that person might end up in the forensic facility for at least 6 months, or like when a competency evaluation, until a competency evaluation is completed. Like, I guess
Well, not less than 6 months, not at least, but like it wouldn't be more than that, except for in terms of how long it took the court process to unwind, because they would have to be reevaluated at the 6 month.
right, so things
Mark.
are proceeding during those first 6 months.
Right.
You know, like the competency evaluations are happening.
Yep, and restoration services are happening as well.
Okay. Okay, I think I get it. Thank you.
Yep,
Is that,
Sorry, Eric, I'm going back to the medical director.
right.
So the concern that I have, and I understand from our witness behind me, Dr. Bowen's point that, the headcount the role might currently be being recruited for. But my concern is that we're referencing a position that isn't currently filled within the administration as of right now. And so once this, to the chair's point, we vote this out on Friday, hopefully by the end of the week, gets over to the Senate, and hopefully the governor signs into law. My concern is that all of a sudden this becomes law, and I know how difficult it can be to find to find the right person for the headcount that we're recruiting for. What if that person isn't? I think there has to be a provision here of if that position isn't filled, or if that position isn't filled, where does the authority go to next? And maybe that's just the commissioner by de facto, but I think that, to me, it seems like there has to be consideration there. I also am curious about the 6 month touch base. And I'm looking at subsection A, lines 9 through 11 on page 2. I'm wondering where that language came from.
Hang on, just jotting something down, because I do want to circle back on this question of, it's an interesting question of if a position isn't filled and the statute designates that person, is there sort of a general statutory interpretation or maybe a rule elsewhere in statute that would then fall to the commissioner to designate somebody else in the role? But I want to look into that because I'm not entirely certain.
Well, and it goes back to our earlier, discussion point of the fact that this falls within the Agency of Human Services and DOC falls within that. Sorry, sir, a comment or a question? My train of thought. Oh, so going back to AHS and DOC falling within AHS authority, it goes back to the fact that in principle, it doesn't really matter what the law says because the authority resides within the same agency. Right? So like the secretary of AHS can easily deputize the commissioner of corrections. That was the whole, theorizing that we went through last time. And so, but anyways, as it applies to the medical director position, it seems reasonable to think that it would just go up the line of command of the secretary. I assume the secretary, but it was a question that I had.
Yeah, and it might be a slightly different answer than the discussion we had last time, because if I remember right, last time the language was broad and was referring to the Agency of Human Services, whereas this one, it calls out a specific title of the specific. And so I'm just not sure whether same logic applies or
not.
You know what I mean? Right.
Yeah, no, and that's why I had the question. Because to your point, this isn't a department or anything other. This is an actual person that we're talking about. Just
right.
Obviously without the name.
Right.
And that's probably a good question for DMH because this is language they actually suggested.
Okay.
Having
Oh yeah, that's a good point.
But so I guess going back to my second question about the 6 month touch bases.
Yes.
Because my understanding, and I've been having conversations with a lot of people outside of the room and outside of the witnesses about this piece of legislation in particular. But one of the conversations I had was that, some people are, very determined to include some kind of touch base, whether it's 6 months or, whatever it might be at the year mark. And my understanding is that while some people might try to model it off of other states, the touch bases in other states are actually just routine check-ins. They're not competency evaluations. So that I'm kind of having that my own personal tension with that of, yes, we can touch base with patients every 6 months and do a routine check-in. But I don't think that should be a competency evaluation every 6 months. Because that's not what's happening in other states. Like, it seems like that maybe that fact has been misrepresented to this room. Not by you, not by you. I just want to state that. I have concerns. I have concerns with that.
Right. Well, that is a policy decision for you guys. As far as the technical, the highlighted language 9 to 11, though, that's more of a technical true up, not really a true up, that's the wrong word. The way the language had been written before, it was the reevaluation would happen 6 months from the date of admission and every 6 months thereafter. But the issue with that language was that the reevaluation may be every 6 months, but then reports have to be submitted to the court, witnesses have to be called, the court has to schedule these proceedings. By the time that the court was able to issue an order as to whether or not the person should stay at the facility or not, it might be 3 months after that. So if you then were having that 6 month clock run from the date of the previous evaluation, then there'd only be 3 months. So that's why I rephrased it as 6 months from the date of admission to start with, and thereafter every 6 months from the issuance of the order for continued restoration, because that way it's a true 6 months, not any shorter, because it could end up have been shorter the way it had been written before.
Right. No, and I appreciate that change. I guess
But that's different from the conceptual question.
well, and that's like what the push and pull that I keep coming back to. So my question is whether, and again, this probably errs on the side of policy versus legislative counsel, but whether there should be some kind of catalyst, because if these individuals, and again, very dangerous population, if they haven't changed or there hasn't been any sign of progress in 6 months, I struggle to see why we would be having any kind of competency reevaluation at that point, because there hasn't been a catalyst for change. And again, very dangerous. I mean, some of these people have been charged with murder. So it seems to me that 6 months in the grand scheme of a sentence probably doesn't make a lot of sense. But I guess maybe that's policy.
Right. I think there's a big chunk of that's policy. The only sort of constitutional element of that I might bring up is that the Supreme Court, U.S. Supreme Court, has said that there are some sort of guardrails for how long you can keep these folks in, and those guardrails involve you can't keep someone for any longer than a period that's reasonably necessary to determine whether they're restorable or not. So that only just leads me to think, as a non-professional, that maybe that in order to find out whether they're restorable or not, you'd have to do some kind of evaluation. So as far as the particulars of that, that's up to you guys. But I think it's sort of as a big picture of why there has to be some reevaluations at some point. That's probably why.
So could we
that. Yeah, I think the time limits are different state by state, and that's the policy thing. But as far as just the general idea that we have to relook at some point in time, there's kind of where the due process guardrails.
Yeah. No, makes sense.
Yeah.
Thank you.
Yep. So I think that takes us through most of page 2. Very bottom, you see some language added there, and because this is, remember, what happens at this 6 month review, right? Well, that's when the court has to decide whether or not the person is still competent or is competent to stand trial or not. And if the court finds that the person is competent, so in other words, they've been getting restoration services for 6 months or so, right? If the court says, well, now they're competent, well, then it's going to order the person return to the custodial status that they had before they were, and there's a typo there, actually, on top of page 3, line 1, that remanded to the secretary language should be placed at the forensic facility. But the new language on the bottom of page 2 is, well, yeah, the court does that unless doing so is going to cause the person to become incompetent again. So obviously it doesn't make any sense for the court to send the person back to that status if that's going to be the very thing that causes them to lose competency. So in that situation, the court does not have that order, and presumably the person could remain at the facility until such time as their criminal trial gets started. So over on page 3, so okay, as I mentioned, what if at this 6 month juncture, The court finds that the person is not competent to stand trial. That's page 3, lines 4 and 5. Well, then they stay at the forensic facility and they get continued treatment. Remember, and they're subject to this review as currently written every 6 months, or when the medical services director certifies that they're no longer, or that they might be competent again. All right, so then this is, and you'll see another instance of it on page 3. You will see frequently throughout the bill the forensic facilities clinical services director being changed to that role that we've just been talking about, the AHC of Human Services medical director. And this part of the proceedings is restorability, because as I was just mentioning, at any time, a party or the medical director can ask the court for an opinion on whether the person's restorable. And it's at that piece that we're going to see the Dale process come back in. So this is a restorability finding that the court can be asked to make. And if the court finds that competency can be restored, that's on line 2, page 3. Competency can be restored. Continued treatment happens at the forensic facility. But if competency can't be restored, then there has to be a hearing within 60 days. That's the bottom of page 3. And the focus of that hearing, remember, is whether the person's dangerous or not. Now, that's going to be because if the person is dangerous, then they remain at the forensic facility under this program of treatment that's in the statute, or in the bill, rather. If they're not dangerous, then they're released under supervision. That's that whole supervised release process. If they're not dangerous. And it adds to that decision that the court can make at that 60-day hearing a third component. And that question is whether the person is in need of custody, care, and rehabilitation, that definition I just turned out, and should be committed to bail, right? So that's being added at that 60-day hearing. So we'll get to that in a second. In the meantime, before the hearing, over on page 4, remember there's a forensic risk assessment that has to be done. A couple of components are added on page 4, Romanets 5 and 6, lines 9 and 11. First one, I believe, was a recommendation from one of your witnesses, the recommendations for treatment and supervision that would support the person's success and mitigate risk of aggression and violence. And then Romanet 6, this one is connected to what we're talking about, the Dale commitment, examiner's opinion as to whether the person is a person in need of custody, care, and rehabilitation as defined in the statute that I just handed out. So the risk assessment is going to look at that question as well. All right. So if the state's attorney demonstrates that the person is dangerous and non-restorable, well, then treatment continues at the forensic facility. That's what subdivision 4, bottom of page 4. Over on to page 5, that treatment, if the person is, again, dangerous, non-restorable, the treatment, it's a highlighted language on line 2, may include appropriate supervision and supervised housing. Their least restrictive needs, least restrictive setting, I should say.
Sure.
Yeah,
Yeah, what's the definition of appropriate supervision and supervised housing?
not a defined term. So that's left to the discretion of the commissioners in the court. But not defined in the bill. Yeah. This continued treatment, if the person's found dangerous and non-restorable, that's also reviewed, but now it's every 12 months. Not because if you're gone that route, if you're dangerous and non-restorable, then the window is longer for reviews. That's line 8, page 5. That's a 12-month annual review. Again, unless the medical director determines that a sooner period is warranted. So,
Yeah. So I guess following along that talk track, Eric, if a person is deemed non-restorable and dangerous, why would they be in the forensic facility at that point? Why wouldn't they be remanded to DOC?
I think the idea there is just that it keeps that population here at the facility. I mean, it's not that you couldn't, as a policy matter, say, we're going to have that person be DOC custody, but I think it's a matter of, that track has kind of been the track that has been in the bill from the beginning.
Yeah. No. I understand that.
Yeah.
I guess.
Not that you couldn't.
Well, no, it goes back to that. Like, how do you define competency, and how do you define restorable? And if someone is defined as non-restorable and dangerous, it seems to me at that point, like the purpose of the forensic facility is for those that the competency is in question, or whether the individual is restorable or not. It just, and again, I know this is a policy consideration for us to have, but it seems to me that it's one worth considering. That why shouldn't that person just be remanded to DOC to serve out their term? Because at that point they have not been charged.
Exactly. They're incompetent to stand trial, so they don't have a sentence yet.
So at that point they would just be they would not be remanded to DOC. I still think that they could be remanded to DOC while they await trial. Because at that point, they've been determined competent to stand trial.
No, they're incompetent.
They're non-restorable but incompetent.
Correct.
Okay.
Now, it's not to say that some of those folks might be at DOC now. It might be. I think
Right.
part of the idea, though, is whether it's a policy matter, you'd
I
rather
understand.
have them treated here.
I understand.
And I think you heard also testimony that at some point there's a due process concern. If the person is incompetent, not restorable, they can't be held forever, even if they're dangerous. And the idea here is in the forensic facility, the treatment turns to like risk mitigation under the forensic risk assessment. That's in part why we are adding the language of requiring, or is the language, recommendation for treatment and supervision that would support the person's success and mitigate risk of aggression and violence. That hopefully we're going to get the person to become less dangerous, and then they can go to a less restrictive environment than the forensic facility. That's the concept.
I understand the concept, but it begs the question of how less dangerous can a murderer be? Right?
I leave that to clinicians. That's not that one, so.
Well, my thing is, but I think this brings up a really important policy debate for us to have is like, what's our comfort level of letting someone out that has been, I mean, at this point, they haven't been charged of murder, but they've been charged but not convicted of murder or homicide. Or, I mean, terror, or any of the other, isms that we, in the list of offenses that these individuals have been charged with, if they become a public safety risk to Vermonters or other people, right? I mean, like we're seeing now people traveling across the country to go to the White House Correspondents' Dinner to assassinate the federal administration. So, but I think there's like a consideration there of like, we need to think outside Vermont's borders, because what happens here, if we're allowing these people out, they can go elsewhere. And then, I hate to even think, I shudder to think that because we didn't fully deliberate or consider the consequences of the legislation before us, that someone else gets hurt because we didn't have protections in there. I don't want to say blood is on our hands, but, I wouldn't want to, I shudder to think at that. That scares me.
No, agreed. And the question is, what level of supervision can there be that will meet due process concerns as well as the public safety concerns? And that's what we're trying to work out. But just locking them up in DOC for however long, it's really not a due process option. It's frustrating.
Oh, no, I'm not frustrated. I'm not frustrated. No, I'm not frustrated. I'm not frustrated. I just think like but if that's why we have the provisional language, and sorry, Eric, I feel like I've derailed your walk.
Not at all.
But if that's why we have the language in there for the 6-month touch bases or touchbacks on this population, then it seems prudent to me that we include that. We include that so that we can hold these people, this population in perpetuity, while considering, on the go forward, their restorability, because they're deemed a threat, right? Like I struggle to think that there's the due process concerns for individuals that have been charged with murder.
But there is, Sarah.
No. I understand that there is, but I mean, this room is, not shy to toe the line with the federal administration or court cases or constitutionality of things. Seems to me like if we're willing to toe the line on constitutionality of bills that we voted out this morning, we should be willing to toe the line on constitutionality on due process here to keep Vermonters safe.
Guess I'm not understanding that. But why don't we go back?
It just seems to me like there's like, when it comes to public safety, there's one consideration on constitutionality. And when it comes to battling the federal administration, there's another concern. So I think, maybe we're picking up on a through thread from this morning. And Barbara, please, with the faces. It's like, you don't need to make your faces and roll eyes.
All right,
It's
so
rude.
let's continue.
It's really rude. You did.
I think people,
It's rude.
go ahead, Eric, with where we are. I think we're on.
Picking up where we left off, page 5. So if the person, we were just talking about if the person is non-restorable and dangerous. So now we're saying, well, what if the person is not dangerous and non-restorable? And that's the release provisions that you see bottom of page 5, goes over onto page 6. And if that's the case, then they're released under this program of supervision. And the language that's new in the bottom of page 5 is it clarifies that who is supervising the person, basically, right? So some specifics there. Could be the Commissioner of Mental Health, could be Dale, could be Department of Health. So it all depends on what condition led to the person having a qualifying condition that led to their being found incompetent. Might be one department, might be another. So this provides that flexibility. Whoever is supervising the person is the one who is keeping an eye on their monitoring their compliance with those conditions. Over on to page 6.
You named a few different departments that may have jurisdiction over the person. What types of places might the department place them?
That's a good question for them. I don't know the answer to that.
Okay.
But I think it is a good question. It's something that with your witnesses, you'd want to find the specifics of what are those placements involved.
I mean, in my mind, is it in a secure facility or in a bed in a town or whatever?
Right. Yeah, I think you could get some testimony on that for sure. Yeah. So over on page 6, the court's order for release also includes those components: housing, supervision by the appropriate commissioner, and that the person is then reviewed every year, annually, and they continue to be on this release status unless the state's attorney can demonstrate that they become dangerous. Victim testimony is also provided for. You see there's a highlighted may on line 19, page 6. That's just because I noted that there's one place that the victim, remember the bill talks about the ability of the victim to have their views heard at a couple of these different hearings. And in one place, the word may is used, and one place, the word shall. So I just want to, should be may in both places. All right, gotcha. Thanks. All right, so that brings us to option number 3. This is the new process over on page 7. This is what I referenced earlier. So again, it's at that 60-day hearing, right? The court could find at that 60-day point, person is dangerous and not restorable, in which case they're staying at the forensic facility, could find that they're dangerous and restorable, in which case they get released. Or the court could find here, option number 3, subdivision 6, that the person is who's not restorable is also a person in need of custody, care, and rehabilitation. That tracks that definition that I passed out. So if they fit that category, well, then the person you'll see is committed to Dale for a designated program. Again, it uses that same language. In fact, this language tracks the language that's in the chapter right now that involves the process that I described at the front end. If they're sent to Dale in the first place, well, this language tracks that language. So it's a similar type of proceeding. Yep.
There you go.
Yeah.
Remember, you said if they're dangerous and restorable, they'd be released.
Correct.
They would be restored before.
Oh, no, sorry. Not dangerous.
Okay,
Yes.
Okay.
Not restorable, not dangerous.
gotcha.
Then they get released. Dangerous, not released.
Okay.
Report, if I get those wrong, it's completely the opposite of.
Maybe I.
No, I probably said it.
We'll blame you.
Yeah, I take it. All right, so page 7. So here's the Dale track, right? Person's found, the person comes under the definition of a person in need of custody, care, and rehabilitation. Well, then they would be transferred to Dale custody. Look at line 12, unless subdivision B applies. See that? There's your exception. Then you turn over to page 8. Well, hey, what subdivision B is a natural question. Page 8, line 3. If the commissioner certifies to the court that appropriate custody, care, and rehabilitation cannot be provided to the person in a designated program, that tracks that exact language, right? That's the language for the definition. If it certifies that can happen, well, in that case, go down to Romanet 1, person doesn't get committed to Dale custody, and 2, court orders continued treatment at the facility until the commissioner does designate, has provided a designated program in the least restrictive setting consistent with the person's treatment. So there's an opportunity there if there isn't yet a facility, a designated program available, that the person can stay at the forensic facility until there is, basically. And then that's the rest of what you see is that process. So line 11, page 8, Again, there's a review of this status every 6 months, or the person can file a petition for review. Again, this tracks language that you have in the Act 248 chapter now. Not less than 90 days after the initial order, and then every 6 months after that. The court finds that there's still no designated program available. They stay at the forensic facility, but over on the page 9 now, Romanet 3. Sorry, that's what I just said. Page 2, bottom page 8 is if the a designated program does become available at Dale, then the court sends a person there. If there's still not one there, they keep them at the forensic facility. That's top of page 9. But on subdivision D of page 9, at any time, the commissioner can certify to the court and say, look, a program has become available. So in that case, then the person would be sent there and the original order would be vacated. So that's how this process is laid out.
So these 6 month periods could go on indefinitely.
In theory, yes. So yeah, I leave that to the witness to talk about how long it typically takes. But
For example, if we had a governor that didn't really want to offer these alternative jail programs, there's no penalty and the person would just stay at the forensic facility and there's no protection for that. Like if that person, the court found, would be best served in an alternative program, the state could indefinitely just be like every 6 months, sorry, we have other priorities that are bigger, and then that person just is sort of skirting the concerns related to due process and being.
I was just going to respond on the due process parameters still exist, so that not indefinitely. The court decisions on that have laid down that sort of principle that indefinite commitment would be a due process problem. So,
But we're doing indefinitely in 6 month increments. I mean, there's nothing to say the state shall put a program in place within 6 months or blank, right? It's
correct. There's no end date specified in statute. So I think that the due process limitations would come into play in court.
so even if we had programs that existed and whoever the governor is at the time, I'm trying to think beyond Governor Scott. So it's not about Governor Scott. They could be like, you know what? That's a lot of money. We're not going to do that. Like there's no rights that this person has to be served in the least restricted setting because the state gets off the hook by saying the program doesn't exist. And 6 months seems like a really long time.
So I think that's a question for commissioners or the other witnesses, probably more so than Eric.
As far as existing least restricted means requirements and that sort of thing, I think does exist in the statute. So that part I think would apply.
But I know commissioners are sort of at the, or beholden to the governor for the budget or the legislature. And so it's not like the commissioners can be like, we're going to just find the money to do that because they might not have the money.
So there is a legislative check on this as well. There is the reporting to the legislature, including the number, how long somebody's been there. So there's not just a presumably legal aid attorney assigned to an individual would the due process concerns if it's getting there, but there's also transparency to the legislature. I mean, that may not be enough, but I'm just pointing that out.
Right.
That's there.
And Vermont would be an outlier in that most states do have a hard and fast, cutoff. That doesn't mean that the person's released to a dangerous setting, but most states are pretty clear on what the defined period is.
All right, well, that's a good question for witnesses as well. Ian.
Eric, I'm just trying to unnest the process in my own mind. So for the 6A, this is a finding on page 7. This is a finding that the court could make at one of these 6-month evaluations.
Correct.
And so is the idea that the state would be putting on evidence to try to show that a person is a person in need of custody care and rehabilitation, as well as trying to put on evidence that they're a person with a qualifying condition? Or is this kind of like the court just sort of has the opportunity to, based on the evidence they have, find a separate finding?
I think it's more the latter, and
Okay.
then that phrase, that process is taken directly out of the existing Act 248 process. In other words, the burden isn't specified, and
It's not,
no,
yeah.
it's not. No,
Okay,
so
yeah,
I think that might be a good question when you ask somebody witness, how does this work now? You know,
Yeah.
but it's a different sort of, if you look at the definition, I thought it was interesting.
yeah,
I wouldn't go so far as to say objective, but the definition of person needing care, custody, care, and rehabilitation, there's some opportunity for proof there, but there's also sort of more clear standards, that the court might be able to find, without necessarily requiring expert testimony.
Totally.
But
Yeah. So they might, all the evidence goes in and they're looking at it and they say, well, it actually looks like maybe this is really more what this person's qualifying as. Okay.
although the intellectual disability piece of it, maybe that is something that's litigated heavily now that I look at it. I don't practice in the area, so I think you could chat with
That's more of it. Okay.
how that process is.
Yeah.
Yeah.
Okay. Thank you.
Yep. All right, so unless there's more questions about that piece that's been added, we can move forward. All right, so what about when we were just talking about release? This is over on page 10. So remember, so that if a person is found not restorable, not dangerous, then they're released under those supervisory conditions that we mentioned. And now this clarifies on page 10, well, who's supervising the person? Who's monitoring them? While they're on release, this clarifies that as appropriate for the needs of the person could be the Commissioner of Mental Health, disability, jail, et cetera. They could be the person, again, depending on the reason that the person was committed there in the first place. You'll see it's the medical director's role in line 14 to determine if the person on release has become dangerous again. Line 17, the commissioner then certifies to the court if the person is returned to the forensic facility, because if the medical director determines they become dangerous again, they can be immediately brought back to the facility.
Eric,
Yeah,
do you see the typo on line 8? I know editing would find it. Yep, it should be up, I think.
oh, yes, thank you. I did not see that. So thank you. Might as well get them early when we see them, so thank you. Involuntary medication process is over on page 11, subsection H. Substantively, not change here other than clarifying that, and this is tracks the existing involuntary medication statute, that it's the state's attorney's burden by clear and convincing evidence to establish that involuntary meds should be provided. Over on page 12, subsection I, this is some new language. I believe it's in response to some witness testimony that the committee heard that when an evaluation is required of the person's competency or restorability, then the defense is entitled to conduct their own independent evaluation. That's on subsection I, page 12. So that takes us out of the competency section. So I'll pause there for a moment.
So on subsection I,
Yes.
what triggers that?
For example, the 6-month review of competency.
Right.
Or in other situations, the 12-month review, depending on the status the person is in.
So that it's interesting because so you have the 6-month reevaluation of competency, and then so I guess my question is, in I specifically, what additional tools, if that's even the right word, or authority does that give the person's defense counsel? Like why would the independent evaluation be needed if, because obviously something's been done at one of these 6-month or 12-month touch bases, and the person has been found to be restorable or I guess like what has been found that the defense counsel would need an independent evaluation?
I think probably it's concurrent, although not always. But for example, in the existing criminal process, there's an evaluation that's ordered by, in most cases, the Department of Mental Health, and they will have the person's competency evaluated, and the defense can have their own evaluation as well. So it sort of parallels that opportunity for the defendant to do that. So
I guess to what end though? Like what is?
I think it's just to the end of how it is that they present their own case.
But would that need to be codified in statute or like I assume wouldn't the defense already be doing that just through course of instance?
Without it in statute, that's a good question.
But that's I guess that's
With,
that's the question I have is like why is it in statute?
right.
And this was a request pointed out by Matt O'Leary.
That doesn't surprise me. Thank you.
I'm wondering if it was also Jack McCullough conceivably. who brought that up. Yeah.
That surprised me either. Yeah.
So it might be a good question for them is like, what if it weren't in statute? Would it be done anyway?
I would, yeah.
All right.
Yeah. And keep going. Sorry, Eric.
No worries. All right, so now we're moving to section 2. Remember, this is a different separate section. This is the one where people who have been found incompetent for misdemeanors, charges are dismissed after a period of time, that period of time being maximum sentence for the offense. Again, this is the other piece that I mentioned where there's an opportunity for the victims to make their statement. So line 18, that should be a may, to be consistent with the previous section. But also added here is the idea that a hearing is not required for all of these dismissals, prior to all of these dismissals, only if it's not a qualifying crime and those are more serious misdemeanors. So, sorry, that would be the non-serious ones. For a serious misdemeanor, those are the ones that the hearing would be required. And there is some other things we can go through pretty quickly. That's most of the rest of what you see in the NGRI section is just going to parallel language that we already looked at. It's all very, very similar, if not identical. So if we're looking at page 14, for example, this is the forensic risk assessment that takes place in the NGRI context, subdivision E, page 14. That's just the same language that you added in the forensic risk assessment in the competency piece. Some language bottom of page 14 clarifying that the state's attorney has the burden. There's some clunky language that wasn't as clear before, but nothing changed substantively there. Page 15, a couple more instances of medical director being used because that's the new role that's being envisioned. Page 16, again, talking about the roles of the different bodies, that it's the medical director certifying to the Secretary of Human Services that the person has this qualifying condition that would create a risk of harm. All of these instances are, again, clarifying the burden of proof, page 17, two different instances there. The housing and supervision piece that you just looked at in the competency context, that's also for the NGRI people on page 17. Page 18, again, exact same changes that we just looked at for the competency piece.
You must have copy and pasted. There's the same,
Oh, is there an O and F? There should have been
line
an
19,
Which page?
page 17, line 19.
Yes, exactly. Thank you. Yes. Oh, not if. All right, so forensic facility definitions, page 19. This is overarching language about the facility. Who is providing this facility? Again, line 5, page 19, it's the Agency of Human Services. Again, obviously, as we talked about, that includes their authority to designate various responsibilities to DOC. Same thing on page 20. It's the Secretary of Human Services who establishes and operates the facility. That's on lines 5 and 6. However, as I also mentioned earlier about how the division of authority and responsibility happens, as you see in lines 8 through 10, it's the clinical forensic and competency restoration services that are overseen by the medical director. So that's their responsibility. You see that reiterated on page 21, that it's the medical director who gives direction about forensic, clinical, and competency restoration services. So that's the party with the authority around the clinical piece. And, page 22, I think is our last, the last few changes. And this is the consultation, subsection E, line 9, that the Secretary of Human Services regularly consults with all the different commissioners that have been specified there. It's the Agency of Human Services Medical Director in subsection F that would be submitting the reports. And lastly, it's the Secretary of Human Services that has the rulemaking authority. There are some highlighted items on page 24, but that actually is from before exactly.
Any questions for Eric before we get to other witnesses? Yeah, why don't you
Just the back to section 2 for the constant stand trial determination dismissal.
Yep.
Yeah. So this is where it's referencing the expungement and sealing.
Oh, right, the offensive that can't be, right.
So I think it's 76014A, which is like the qualifying crime. For it. And I think it's actually a really clever way to do it. But it's a little confusing because it's if the offense is not a qualifying crime under the subdivision, and the way that the subdivision reads is that a qualifying crime are all misdemeanors offenses except. So it's like I'm trying to I wonder if it's the clearest way to do it.
You're identifying something that gave me a headache after about half an hour. I was trying to think, I'm like, how do I phrase that?
I'm trying to
That was exactly what you mean.
yeah.
So it may be that I didn't get it right. If I'm like, I think I have it.
I don't know if it's there. I mean, I understand what we're doing.
Yeah.
I just I don't actually know if what this says is actually.
Right. I know exactly what you're getting at, and I'm happy to, let's follow through with it so we can make sure we
get it right.
Yeah.
Okay. I was
100%.
Great.
like that?
Right, that's right. Like a Rubik's Cube. Situation.
Very. So I'd like to start actually with Dale, since I spent most of the time in Dale, and I'm going to apologize up front if we don't get through everybody today. We do have time tomorrow morning as well set aside for any additional testimony on this particular draft. So thank you for being here, Dr. Bowen.
It's starting to feel like home. So Bill Bowen, Commissioner Dale. I just have a few points. I mean, for the most part, this is workable for Dale, but there's a couple of nuances that I just want to raise. One is that the definition that Eric read for the Act 248 is correct, but it's specific to people with intellectual disabilities and not the whole universe of people with developmental disabilities. That's one nuance. For those who meet the definition, the Vermont definition of developmental disabilities, which is a specific definition based on CMS and our waiver and all of that, but those folks we can also provide programming for. There's a difference between custody, which is Act 248, and intellectual disabilities not competent, and the developmentally disabled group that wouldn't qualify for Act 248, but for whom we are able to provide services because they fall under the definition agreed to for our waiver. So just to be clear that those are the two populations that through developmental disabilities services, inclusively speaking, we would be able to either take custody for where we can, or supervision where there is no custody in law. And those are the kinds of programs we currently have up and running. And when we have a situation where there's a special program that is needed because of the challenges that the individual is presenting with in terms of risk to the public specifically. It takes us a minute in this state to put that together because you have to find the appropriate location. It has to be available. I'm going to talk like looking for a house, right? It has to be affordable. It has to be in a location that is somewhat more isolated and where there can be significant supports that surround that person in the community. And that's how we balance the the support of the individual and the continuing work on risk mitigation along with protecting the community as much as we can. So just want to be clear that those are the populations that we can serve and how we do it and what makes them slightly different populations. So the fact that it could take us a little bit of time to find that specific is different than other states where there are lots of opportunities and places where people can go. And so that's why we might ask the court. So the least restrictive environment is not available necessarily immediately, but would become available in reasonable period of time.
So before I go to you, Ken, just want to clarify something on that. So are you talking mainly, this is on page 8 and 9, the process and the person's going to remain in the forensic facility pending finding a placement, outside of that. Is that just for intellectual disability as you read that whole section?
Would be for the intellectual disability and for the developmentally disabled who fall under our definition. And join me if, can I ask something?
Yes, if you just identify yourself. So,
Yeah, this is Stuart Sher, General Counsel at Dale. The section that the commission is referring to there for Act 248 purposes, when someone comes into the commissioner's custody, that is exclusively for people who have an intellectual disability. The other section, I think it's C5, is where we're talking about placement in supervision, but not the custody of the Dale Commissioner for people who have anything other than intellectual disability and couldn't go into Act 248 if they're not restorable.
As long as they meet the criteria for Vermont's developmental disabled.
So I guess there's maybe one, you heard that, there may be one hole here, because that's on page 6, and that's supervision for those who are released from the forensic facility. And they have to be found to not be dangerous at that point. What I'm looking at is on page 5, it's at the very top, where somebody is found to have a qualifying condition which leads to the substantial risk, but they're not restorable. And it's that the court shall order treatment of the person, which may include appropriate supervision and provides housing in the least restrictive setting consistent with the person's forensic risk assessment and treatment needs. Seems like there's a place for Dale there as well.
There is a place for Dale. So when the person has some level of risk, not zero risk, Act 248 already has that as part of the criteria for being able to come into custody, right? So it would be a place where Dale would.
But that's for the intellectual. I'm talking like if somebody that doesn't meet that is developmentally disabled or has a traumatic brain injury or.
So let's separate these two. Okay, so if it's a developmental disability, Dale can bring the person into supervision. There's no such thing as custody for them in our laws. And we serve that population. We have we call them on our public safety roles, right? So they don't meet the criteria for Act 248, but they still could present a danger to community, or their behavior is such that, and we do have supervision and we do have services that, are provided for the purpose of helping them to do well in the community, right? But some of those people, they also need some sort of intensity to the type of supervision that we provide. So yes, so Dale can bring those people into the community, but it wouldn't be in our custody.
Yeah. I understand that, Ken.
Brain fog, maybe not. CMS, what's that stand for?
Centers for Medicaid and Medicare Services.
Thank you. Good job.
Did you say that? And, so we're basically talking about the home community-based services waiver, the services that we provide.
I got totally lost. Then mine was a quick thing and goes on for.
You good now?
Yeah, well, I'm better, but I was lost in 10 minutes, so that's okay. That's not your fault, that's his.
Well, we might have services. Let me just say,
Angela.
Okay, so I just wanna, I'm pretty sure you just explained this, but I wanna make sure I'm understanding. So, because I noticed that the statute that was shared with us, that Eric shared with us, only mentions intellectual disabilities, doesn't apply to developmental disability. So as you read the proposal, in S-193, are we taking care of, we're addressing folks with developmental disabilities? They would also be supervised by Dale.
They would be
not in
supervised.
custody of Dale, but they would be, placed in the forensic facility, potentially placed in the forensic facility to begin with.
Mhm.
And then presumably over the course of, a competency evaluation or perhaps other
Mhm.
observations. There would be someone to say, hold on, this individual has a developmental disability. We should be choosing a different track and engaging with Dale.
well, yes, for those who meet the state criteria. Yes, the expectation has always been that we would be serving both of these populations. We do currently serve these populations. There are 3,400 people within our developmental disability services, home and community-based, and right. And about 30 are in Act 248. There's a larger number in the non-Act 248, not in custody, but in our care or in our service provision, right? And so we already do things like find appropriate housing or settings, residential. It could be a shared living provider. It could be some level of group home. It could be in an isolated space with some sort of 2-to-1, 3-to-1, 24/7 supervision. It really depends on what the person's presentation is and what the challenges are.
Yeah.
So,
And I just want to make sure that we're not doing anything, introducing any ideas here or, tracks or processes that interrupt that
great, thank you.
existing person.
I really do appreciate that. Now, let me just say that when we say we might need a little bit of time, the folks who are currently incarcerated without any opportunity to have competency restoration currently, and who are determined to either need Act 248 or to come into our services, can stay there for a long time waiting for a program to be developed or be released prematurely when we don't have the full program up and we are scrambling. And that leads to potential risk to the community. So this actually gives us another tool to be able to have some time. You do not want someone in isolation or sitting somewhere in jail without even having an opportunity to have risk mitigation ongoing. And I do think that the AHS medical director role, where it's the custody is with corrections and the medical matters, as we were calling it, are in the role of the medical, would include risk mitigation efforts, which are, efforts to provide the type of intervention that helps people be able to manage their impulses, to regulate their emotions, to be able to have coping strategies so that they can increasingly be able to safely be in the community.
So I'm wondering if there's any sort of federal guarantee for services for people so that the money would flow if the person arrives? Like,
Money, let's talk about money. So several things about the funds. So through the Home and Community-Based Services waiver, and this is Medicaid funded programming. So that's why they need to meet the definition that we were talking about, right? If there is a need for additional funds beyond what we have, which occasionally can happen, sometimes it's appropriated through the legislature. Sometimes it's we're able to work that out with the administration. But for the most part, we do have the funds and we manage them to create some of this type of programming. So we have them stood up right now in certain places.
and is anybody of the people that you're serving, like, on the waiting list to get into things? Or it's not the same as Department of Mental Health, where people at some of the designated agencies, there's a waiting list for.
So the Department of Mental Health will speak very well for themselves. I'm sure. But there is a difference in the types of programs and interventions that are provided. So we got some apples and oranges here. And we do in DS services ensure that there's appropriate housing for folks. That's part of why we may need some time to set up the appropriate, but sometimes that is like I said, like a shared living provider. It could be group home. It could be a space that's rented or even bought in some cases, right? To have some level, but we also have sort of crisis level where we might have somebody or some sort of temporary situation while we're waiting to obtain the apartment or like that. But they're not left on the street, right? So that's never, they're under our supervision. We're watching.
And I don't know, and I guess it's another committee, but it's helpful to know. The idea last week, at least, was it that they would use the Alpha Wing at Springfield for the forensic facility?
I really don't have that answer.
Okay.
And again, I always said that I am of the opinion that it's what's going to happen inside the facility that is the most important piece of it.
In talking to some of my colleagues who just toured that facility, I mean, it sounds like it's a row of bars and cells. And I'm just wondering, I know people can not do well in an emergency room setting. And so moving people who are in crisis, to sort of alternatives to an ER has made a difference. And I'm just wondering about the ability to help people get restored in.
So each of the individual, so I think, what you're talking about sometimes comes up with folks who have autism and some other folks who are easily stimulated or just the organization. I mean, that's true in the courts too, to have some level of accommodation. I think that what we're talking about is trying to develop something that's therapeutic, a space that's therapeutic. But the most important piece of that will be how the interventions are provided, who's doing that provision. The idea of putting it under a medical director of sorts makes sense to me. You have a different set of eyes on when you're looking at what is the facility, how are we providing the services, what does each individual need, because they won't all need the same thing. People with developmental or intellectual disabilities are not a monolith. Neither are people with mental health needs, right? So there has to be some level of individualized approach within whatever the setting is.
Are there like either licensing or statute guidelines that have to be followed for the types of residential, temporary, or longer term that you have to follow?
Yeah, well, so some of them are licensed, some of them do not need. There are certain criteria for what goes on in there, whether it's 24/7, how many people they're serving. There's certainly, we have a system of care plan, we have, rules, and then there's CMS rules, you know, CMS, right?
Yeah.
So there's all kinds of rules and regulations, some of which are state, some of which are federal guidelines for what is appropriate.
I'm familiar with ones in other human service areas, but not these, so just was curious. I assume there were, but thank you.
Thank you.
So back to your other nuances, if there are more, or did we cover the ones that you wanted to cover?
Do we have more nuances?
Or
Nuances from
any
you?
other suggestions?
We talked a little bit, I'm sorry, stewardship. We
Yeah.
talked about the developmental disability folks who come under the supervision of the Dale Commissioner, but there are other folks that we serve.
Oh, thank you. Okay, so when you get to something like the TBI or maybe even dementia, that sort of thing. So there would be some sort of a parallel that they met the criteria for our Choices for Care program or one of the other programs that we have available. So it may not be that everybody that comes in with some level of issue there would fit into one of our programs, and it might have different ranges of what you would be calling supervision related to that. It could be that they would need a long-term care facility, in which case that is right in that sort of wheelhouse. But there's also other possibilities in terms of what their needs might be. So just in terms of, again, not everybody's needs are going to be the same, and we may be able to provide supervision for those, but depending on what their scenario is, it may depend on whether they are kind of eligible for the types of programming that we could supervise.
Any questions? We're getting closer.
Yeah, I did want to, there is a place where, so there was concern I heard here where, will they stay forever? I want to make sure that that's not what I'm reading here. I'm reading that there is an exit strategy in here, which has to do with either coming into the community through one of our doors, or for the individual themselves to be asking for a review, because that seems to also have been in there, Eric, right? So that was important because they are active in their own situation as well to be able to ask for review. So I just want to make sure that we know that even as they're working to help them get to a place where they have more success in the community, they've still been charged with a crime. Once they're non-restorable, we don't know whether they ever actually committed that crime. But nonetheless, there is a risk to the community, and we have to take that into account at the same time. But even folks who sit right now in the jail for long periods of time because there is this gap in Vermont, eventually are released. This release will be actually safer for the community.
Yeah, not to put too fine a point on it, but right now, individuals could be held and their exit strategy is eventually having a due process hearing, possibly. I mean, so this is actually providing, and we're trying to increase and make sure that we have these exit plans in here. So.
Right. Do you remember the first day I came here, I talked about two circles and they cross over like a Venn diagram? Okay, this is getting into that sweet spot. So I am, with the nuances being taken into account, I think at Dale, we're comfortable with what you put together.
Appreciate it. Thank you. So let's hear from Commissioner Hawes next. I'm assuming that Stuart, you weren't going to separately testify.
I have nothing to add.
All right. Okay. All right.
It's a moment.
Yeah. Well, I could come up with something, but we can. Sorry.
Thank you for being here.
Yeah,
I
thank
don't think
you.
we've heard from you yet on this.
Oh, well,
We've heard, I think,
nice to be here. Well, you usually hear from Karen. Because of course, with her role, she's certainly a content expert, but just real quick for the record, Emily Hawes, Commissioner for the Department of Mental Health. And I want to say thank you to the committee for spending so much time on this piece of legislation. and the thoughtful dialogue surrounding a group of individuals who've been, charged with very serious crimes, and putting a system around folks that doesn't currently exist. So one, I would like to offer a couple of points of feedback related to draft 4.1. And that is around the language of custody and supervision.
Give you points to the page.
Sure. It's around, let's see, page 6. Maybe starting at the bottom of page 5, line 18. The language starts to describe custody and supervision as sort of one thing. And currently, the Department of Mental Health, the Department of Health don't have a structure around supervision. We have custody, DMH does, through the O&H process. But from our lens, the language in line 18 and down, where it talks about supervision, that is not a structure that we currently have within our system. We do have the O&H structure, and that is a clinical-based structure, O&H meaning orders of non-hospitalization. If somebody has a clinical need related to their mental illness, there are court processes to engage in a higher level of care. And so what's missing out of this language is the role of the Department of Corrections in overseeing and supporting those conditions of release that individuals are in or on once they've been discharged from the forensic facility. And that collaboration between the clinical team, say at DMH or the Department of Health or Dale, partnering with the supervision components at the Department of Corrections to collaborate together to meet the needs of that individual's safety in the community. And so the Department of Corrections is left off the list of individuals who are at the table working on an individual's safety in the community. And so I would ask that we consider adding the Department of Corrections back into that role, because we see them as a valuable component to the supervision piece in the community.
So it'd be Commissioner of Department of Corrections and one of the following, actually, Commissioner of Mental Health.
Yeah.
I already had that even on my list before.
Oh.
Commissioner.
Oh, great.
I noticed that was kind of a missing point, but thank you for adding.
Yeah. And we have, yes, and we do have very positive examples of shared supervision where the clinical is informing and working with the supervision and working together to support that individual's success in the community. And that's not, my concern is that the O&H process is almost exactly what's already identified here, and that's not serving our community well for this group of folks who are presenting with some complex challenges related to violence in the community. The other components are around language specific to supervised housing. The Department of Mental Health doesn't provide supervised housing. We have, if there's a clinical need, residential programs, but that wouldn't necessarily come into play here unless that individual meets the definition for a serious mental illness and needs a residential placement based on their symptoms of mental illness. So there are some nuances in that supervised housing that I think could use a little tweaking.
Do you have a suggestion then?
Well, I'm thinking as I'm talking, which is never good for anyone.
Also.
Yeah, well, I can't. She's unreachable. So that's why you have me.
as she should be, unreachable, not that anything
Is
is.
she available this week at all?
She's not available this week at all. But I can think on some language, we could general terms like appropriate housing. We just don't have the system to do supervised housing in a way that would lead to somebody being placed back into a facility if they're not following the treatment rules, because it's very treatment based. And so let's say somebody misses a therapy appointment, we're not going to that there's just no system wrapped around the supervised housing component. So my initial thought would be to have it be more vague as like appropriate housing or something like that, because a lot of folks live independently who experience symptoms of mental illness. And again, but we're talking about folks who have very significant charges.
I suppose, and I mean, this is a question for legislative council as much, that we have down housing, I'm just looking at page 5 and 6.
Yeah.
And as one of the items that would be in an order, but the court could presumably order that housing is not available or it's not appropriate in that situation. It's not, or is this language require that they have to provide housing there?
Well, it depends. I think that if they have to comply with the prescribed regimen.
Right, which may or may not include.
Previous, yeah, so that may or may not have included housing. So, room number 1 to page 5. So if that prescribed regimen, right, because that is the prescribed regimen. And then if that included housing.
And then the point is, if it includes housing,
Yeah.
that's not demanding that include housing or any particular thing, because there may not be medical, it may only be psychiatric, that's kind of, so I think it's that flexibility is there, Blaine, so I just wanted to confirm that with Eric.
Yeah, and I think the word appropriate sort of already appears, because all of that is modified by the last one. The agency human service medical director certified as appropriate.
Yeah.
So maybe
Okay.
if there's presumably R&D departments, then the agency are communicating this to a feedback that, well, if we don't do that, then that would be a bad part of that person.
Okay. And again, we would rely on our partnership with the Department of Corrections for orders that would require somebody to live somewhere.
So last week, I don't know if you saw the testimony from the medical director at the Howard Center, blanking on her name right now.
Dr. Robin, yes.
Right, who also does the work at Yale. And she had talked about the continuity of providers. So I'm wondering how that works with having corrections doing it, and how to have corrections probation officers trained in whatever treatment modality
Yeah.
people are receiving. Why? Because you provide a lot of services through your contracts with your designated agency. So I'm wondering why you wouldn't go that route in order to play up the strengths that you have from
Sure.
those providers.
I think that's a great question, and I did not watch Dr. Robin, but I am familiar with her work. What I would say is that current state, numerous designated agencies, not all, have contracts with the Department of Corrections to provide risk reduction services and work closely with probation officers to provide that collaborative care to individuals. And that's a lot of several folks who this would likely impact are likely also going to be receiving mental health, substance use, or other types of clinical services. And having the collaborative partnership with DOC is an effective model where treatment stays in the treatment lane and the safety and supervision stays in that, but they work together. And there are strong examples of that going quite well. I would say in the violent offender space or the batterers intervention space or the sex offender space out in the community, those are strong working relationships that are successful in that collaboration. If somebody needs to go back to a correctional setting, then they can work together to make that happen if that's indicated. just that we do support the forensic facility targeting the group of folks that this very specifically defines and seeks to serve for our communities. And again, appreciate the time the committee has spent on it.
Great, thank you very much.
That's all I have. Yeah, thank you.
We'll hear from Kim Janice. Well, unless you have more than 20 minutes of testimony, Kim, then I'll have you back tomorrow. But, 'cause we have to end at 4.
More how you all are doing. You've had a long
Uh,
afternoon. I'm
are
happy
you
to connect at 9. Fresh, ready to go.
How about we'll schedule you for tomorrow at 10?
2:10.
How about 9:30?
That I can do.
9:30. All right, yeah, let's adjourn until tomorrow, 9:30. I agree. You're reading the room.
Yeah.
I was-
Yeah,
just
I was
as
gonna
was
give a
reading.
little pep talk. I had it all ready and I was like,
This
this
is-
sermon's done.
I was getting the same vibe.